It's August 18th of 2026, and this is the Court Gallery. We start with Judge Middleton hearing about a chaotic water festival brawl and a crazy neighbor dispute. Then we're headed to see Judge Aquilina as she drops the hammer on a defendant whose blatant disregard for probation earns him special consideration. Tensions continue to escalate when Judge Stevens is tested by a heated clash between attorneys over potential witness intimidation. And this judge has no patience for such nonsense. Finally, we wrap up with a habitual offender whose family begs for intervention, only to watch him complain about his impounded truck. Can these priorities get more messed up? All that and more starts right now.
This is file 261470. This OM. This is ordinance case. Take a look. Ms. Holderman, you got charged with disorderly person. They filed an actual complaint. They allege that on June 19th, that's like water carnival time, you were a disorderly person. You got in a disturbance fight or quarrel in a public place at Water Festival with another girl, Aya Treestrom. That is a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. You have posted a $200 bond, which would be enough to pay the fine in this. Mr. George, have you had any consideration on this one?
We would do a civil infraction.
All right. Well, Ms. Holderman, what you're charged with is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. Mr. Tim George, the Three Rivers City Attorney, has agreed to dismiss that charge if you plead to a civil infraction. Three Rivers has a certain ordinance. There's no state law that fills that role, but it takes it from a crime to a civil infraction, like a speeding ticket. It doesn't go on your record as a criminal offense. The fine is $100. You have $200 of bond money. So I could use $100 of the bond to pay the fine and give you $100 back. So that's the offer, to dismiss the misdemeanor if you plead to a civil infraction. You also have another unpaid retail fraud fine, so I would use some of your bond to pay on that. Are you willing to plead to that civil infraction charge?
Yes, Your Honor.
Anybody threaten you to get you to do that?
I'm sorry?
Anybody threaten you to try to get you to do that?
No.
Or promise you anything other than what I told you?
No.
Very good. Who is Ava Treestrom?
I don't know her.
Did you get into some sort of a scuffle down at the water carnival?
Yeah.
What happened?
So we have been walking around and she had some friends that had some arguments with my little brother, and they had been following us around, and basically I had caught them out on what they were doing and she didn't like that, and she started screaming at me and it just made me angry, so I had to fight her.
Well, what I say about disorderly person, it doesn't matter who started it or who was right or wrong if you were in the middle of a disturbance fight or quarrel in a public place, and that sounds like what this was. All right, you don't plead guilty to a civil infraction, you admit. Which Holderman family are you from? Well, who's your folks?
My dad is Doug Holderman.
Okay.
Holderman Jr.
Well, there's a lot of Oldermans around here, and Doug had 4 brothers and 2 sisters, I think. So, there's a lot of people out there. Name. Did you spend a night in jail? You just posted the $200 bond? All right, apply $100 of bond to fine and costs here. Apply $100 of bond to your unpaid ticket, which is the retail fraud. That means you still owe $70 on that old ticket. So I'm gonna have the officer take you out and you can set up some sort of plan to pay off that retail fraud ticket. And you're good. So let me repeat, this was not a crime. It won't go on your criminal record. You pay $100 fine for getting into a quarrel with another girl at the water carnival. Water festival. All right. Pay that other $70 off within a month or so and you'll be square with us. I forgot if I asked you, what do you do? Do you work someplace?
Yeah.
Where do you work?
I work at Applebee's in Three Rivers as a server.
Well, I don't get there much, but if I do, I'll say hello to you. Thank you. You're good to go.
Thank you.
This is People versus Stephen Wilkins. The file number is 261176FY. Mr. Wilkins was charged with carrying a concealed weapon and possession of a firearm under the influence. This is a complicated set of facts and a strange set of circumstances. Defendant pled to possession of a firearm while under the influence, and I asked for a pre-sentence investigation. So Matt Huff was assigned to that task and has done a very good pre-sentence investigation report. But circumstances changed since the time this was charged and pled. The defendant got arrested on a new case, file 261318FY is the district court number, which is a child abuse second degree. That matter is bound over to the circuit court and the defendant's in custody in lieu of a $45,000 bond. So he's been in custody, I think for 36 days, plus maybe a couple days at the front end. So the circumstances have changed really since the time of the plea here. At any rate, we do have an odd set of facts, defendant with a significant substance abuse issue, frightening circumstances, drunk driving charges that were never really established. And the defendant now has 36 days of clean time. I'm interested to engage with him here in a little bit. Mr. Knopfinger, what would you like me to know?
A couple things, Judge. In addition to the report, the plea was to possession of a firearm while intoxicated, which is a 93-day misdemeanor, Judge. This is one of those that is presumed fines and costs, no probation. I'm aware that the circumstances have changed. Discussing with my client, he is entitled to jail credit, pretty significant bond in the criminal case. I'm told that's set for status conference on Monday. Quite frankly, 37 days for the facts of this case does seem appropriate. Thank you.
Mr. Gabriel?
Totally disagree, Your Honor. Your Honor, I'm familiar with the case. I actually issued it. I remember reading the report. I am well aware of Mr. Wilkins' behavior, and his intimidation of his neighbor, who happens to be someone that we know and in fact works for the county, resulted in her calling the police because she was so frightened and so scared by his drunken behavior. And it was upon the police responding, Justin Van Dyken, Deputy Van Dyken responded, found Mr. Wilkins to be extremely intoxicated and carrying a loaded gun. So I charged him with that. Ms. Davis decided to give him a real opportunity here, and he promptly turned around and blew that away by the probable cause determination of what he did that is now pending in circuit court. This man, regardless of it's only a 90-day misdemeanor, the fact of the matter is the facts and circumstances clearly indicate he has a substantial substance abuse problem, and we may ultimately hope that matter can be addressed in circuit court. But for the court not to address it now and just say, oh, credit for time served, and that's okay, I think would be a total disrespect to the system. We have to look at the facts. Certainly, we look at what the outcome is because that's how we move cases. You can't try every case that comes through the system. And I have no problem with the opportunity was given, but I also recognize that he totally abused that opportunity. And I specifically recall handling the new case up here. And there was a mental health component that family members were very concerned about. It might be a mixture of alcoholism and some mental problems that need to be addressed. And I think it's better to get started on it now than later and hope it's addressed in circuit. So I think the jail time, fine, that's enough for that. But 90 days is 90 days. The court can put him on probation, and we still got more time to work with if he doesn't conform to the probationary terms. Thank you, Your Honor.
Mr. Huff, you drew this case, and thank you. You had a little trouble getting started and getting the thing done, but then the circumstances changed with the new case. You tried to sort out what actually happened. The facts of this night are unclear. He was driving drunk up and down the roadways. Again, that wasn't charged because it didn't fall that way. He also had more than one gun, as I understand it. There was a 22, and then I thought there was another gun. Then in the meantime, after you'd started this, you got arrested on the new charges. So anything you wish to add regarding your pre-sentence report?
Yes, Your Honor. I'll just add a little bit of context. I mean, as you've stated before, this is an odd set of circumstances, kind of strange parsing together of the facts had to occur in order to get a general idea as to what's going on here. But I think that after speaking with Ms. Patch about what had happened on that day and kind of trying to reconcile the stark contrast of the two stories, that's where the substance abuse and mental health issues come into play. And I think it allows for a better understanding as to why the two stories are so far off. I think that Mr. Wilkins is at a point right now where he's willing to acknowledge that he has a substance issue, primarily hinging upon his mental health. He spoke to me directly about how the wear and tear on his body through his career in the type of field that he was in is now gotten him to the point where he would normally be looking on retirement and being able to live his life the way that he would like to, and he can't because he's got some physical ailments. And I think that's been weighing on him. And it's gotten him to the point where even his wife in the police report acknowledges that perhaps Mr. Wilkins was having a mental health crisis that day, and then the alcohol was not making it any better. So, you know, from Mr. Wilkins' perspective, he was at the road, didn't go up to the house with Miss Patch, which was how the police were called to this incident in the first place. When I spoke to Miss Patch, she said, absolutely not. That is not what happened. Mr. Wilkins was up inside my garage. She was there alone. She was very, very frightened. I want to emphasize the fact that, you know, even though this is a possession of a firearm while intoxicated charge, there's more context to it beyond that. There's a scope that essentially his neighbor or maybe even neighbors were feeling very uncomfortable. His mental health and substance abuse had contributed to his behavior enough to where it's affecting other people at this point. So the good news is when I spoke with Mr. Wilkins, he seems to be on the track for acknowledging that. As you had mentioned before, this was on a track for a delayed sentence with even further reduction if he was going to take care of the problems that he had going. And then it was complicated by the fact that he was charged with two new felonies in one singular case. But so he's been sitting in custody for 36 days. He was arrested on this one. So he did 1 day. Together, it's 37 days credit. Initially, I was thinking 37 days in jail for a charge like possession of a firearm while intoxicated would be appropriate. When I got to more into the case, I see why reformation of the offender is a very relevant sentencing factor. And so I made a recommendation for a period of probation. I don't want to rely on a circuit court case running the course in order to, hey, we'll start a probation afterwards. I think he needs a little bit of help getting on track so that he can live the rest of his life in harmony with his neighbors, with his family, and enjoy the way that he ought to. So I did make a recommendation for a 12-month probation. I think it's important for him to complete the firearm safety course as well. I've had other cases like this before. His CPL was lapsed. And then on top of that, he's intoxicated, obviously. So maybe a refresher as to what's okay and what the consequences can be would be appropriate. It's not that hard to get into one of those classes. It's a 1-day thing you can do on the weekend. It takes about 8 hours. Drug and alcohol testing and treatment, I think, are very vital to this. I would also add, it's not explicitly on the recommendation. However, I meant to add it in there. I think that a no contact to appear at the residence of Melissa or Don Patch and family would be appropriate if he's placed on a probation. This made them feel extremely uncomfortable. At this point in time, they'd like to have some space, and so I think it's relevant to this case.
That would be, in my mind, the main reason to do probation. He may well not be out of custody within 12 months, depending on what happens with the other case. And so your report is assuming nothing regarding the felony case, just on the merits of this case alone. But there was also, it's hard to separate the alcohol from a mental issue. And it should be noted that you were also on a bunch of pain meds. You're on Oxycontin, Percocets, I don't know what else, and you're mixing alcohol with it. And your conduct this night was so bizarre. You're on a motorcycle, you're in a car, you're on a lawnmower. I wasn't clear whether there were more than one gun. The report says you were going to go out and shoot some holes in a barrel. And then some things happened. Then you went back to the house and said you retrieved the 22 caliber revolver. It's an odd kind of a gun, a 22 caliber Ruger revolver. But it is a gun. Putting the gun under your coat and carrying concealed or in a vehicle is a felony punishable by up to 5 years in prison. Standing around with it drunk is a 93-day misdemeanor. It seems to be a little disconnect. Anyway, you were in the throes of a significant mental health issue. You've now been in jail because of the other case for 36 days. So you got no alcohol. Are you taking your meds as prescribed?
Yes, I am, Your Honor.
Just one thing I will note, you look much better than you did at some of the early occasions I saw you. So now that you got 36 days clean time under your belt, an opportunity maybe to reflect on this, is there anything you want to tell me?
I'm done with drinking. I would appreciate another chance at proving myself. I don't want anything to do with that. And if I can stay away, I was diagnosed with stage 3 kidney disease, and I was informed that I should cut back on the medication as well. So I needed to get straight on that medication. The doctor that I was seeing at Covered Bridge and I had talked about, as of July 1st, new programs coming to Three Rivers, like the 14-day programs, but she wanted to go slow on the pain medications to bring me off of them. But she said there were certain places that there was different medications that I could try to do that she didn't recommend it. So we weren't quite there to a stage yet. The day before I got arrested, the 15th, I actually had a meeting with Pivotal, but I got put in jail on the 14th.
All right.
I would be willing to do another program.
Mr. Dobsinger is correct. Under the Criminal Justice Reform Act, there is a presumption that in non-serious misdemeanors, there won't be any jail or any probation. It is only a presumption. It can be overcome by factors. Some of the factors here involve the conduct and then the post-arrest conduct, which resulted in the felony charge that is holding you. I can think of a case where a prominent St. Joe County citizen got involved in a rollover traffic crash, and he was drunk and he had a gun in his possession, and he got 1 day in jail from the Kalamazoo County judge. But this isn't a 1 day in jail kind of a thing. My original thought was just sort of a fixed jail sentence and leave you to the circuit court. The odd thing about this is I don't think you were mad at the patches. I think you were just drunk and mad about I'm not sure what, and they happen to be in your path. I don't think you have any particular animosity toward your neighbors, but you scare them. And I don't know what you were doing. You were like a pinball. But I am going to follow Mr. Huff's recommendation for a 12-month probation. It made me move if you don't get out of jail. On the other case, I am going to order 60 days jail, credit 37, leaving 23 days to do. That leaves some days that could be instituted if you violate the probation. These will be concurrent with a felony case. In fact, that's why you're in jail now. The district court number of that is 261318FY. No contact with Don or Melissa Patch. That's the main reason I'm even putting you on probation. We'll do firearm safety course if that can be accomplished. Firearm and the ammunition are forfeited. That's by statute. I told you that at the time of the plea. I don't have any discretion in that. Firearm is to be destroyed. You did post a $2,000 10% bond. I'm going to assign $125 in costs, which is a $75 crime victims' rights fee and a $50 state minimum fee. The court keeps 10% of a 10% bond. And so I'm going to 125 and 55 attorney fee, which is 180. We'll apply 180 of bond, so you don't owe any money. I mentioned one of the other factors. I didn't mention why I felt this was more than a non-serious misdemeanor is all the driving. You're driving a motorcycle, you're driving a car, you're driving a lawnmower. Drummond Road goes like this. It's very hilly and dangerous. And again, that's a danger to the neighbors and the public. At any rate, this is a probation that may not be hard to supervise. I'm doing 0 probation oversight fees. You're in jail. So you may not do anything for 23 more days, even if you had $1 million to bond out. And if you do bond out, then you're on the probation. If you don't bond out, that case will go on its own path. It has a status conference next week. All right, Mr. Wilkins, there's not much more to say. You're free to go with the officers.
Thank you.
We also had the matter of Danielle Renee Ballard, charged with driving suspended second offense on July 31st. Miss Ballard was killed in an automobile accident. A nice young woman with a suspended driver's license. There is a GoFundMe page to help pay for her funeral, but she isn't here, and this case will show as closed. Miss Ballard, I think the accident was about August 10th. Terrible. Anyway, that case will be dismissed.
All right, do we have Mr. Thompson?
He's going to appear as in your honor, as he was brought over from jail.
Okay, so do we have them over here? Well, there, is this him? Post two? Sir, are you Mr. Thompson?
Yes, yes, Your Honor.
Okay, and you can hear me?
Yes, I can.
All right, thank you. This is docket 24919 FH, People of the State of Michigan versus Calvin Lewis Thompson. Counsel, your appearances for the record.
Good morning, Your Honor. Steve Barbucks, on behalf of people in the state of Michigan, you're at probation. And good morning, Your Honor. Frank Harrison, Ingham County Public Defender's Office, here on behalf of my client, Mr. Thompson, who appears via Zoom from the Ingham County Jail. And just for the record, Your Honor, I talked with Mr. Thompson. He consents to this hearing being conducted via Zoom.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. You put your hand down. Have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
You've had enough time to speak with your attorney?
Yes, Your Honor.
All right, and I understand my staff has been working with everybody this morning before we got on the record because our equipment is not exactly working. So we've kind of piecemealed how we're doing this. So if at any time you can't hear me or anyone else, please let me know. If it goes down, just raise your hand. We might need to reboot the system. I'm not sure what's going on. So you just let me know either verbally or by hand signal, okay?
Yes, Your Honor.
All right, and you're okay with your attorney being here and you being there, is that correct?
Yes, Your Honor.
So I think you were in a breakout room earlier. In the event you do need to talk to him, all you need to do is let me know and we'll put you back in a breakout room, okay?
Yes, Your Honor.
All right, very good. So, sir, you pled to child abuse, fourth degree, a 1-year misdemeanor. And as part of probation, there were certain terms and conditions. I now have a warrant that the court signed that alleges the following. On July 21st, 2026, community mental health staff confirmed defendant was terminated from individual therapy. On behalf of probation, is that the extent of the violations?
Your Honor, I had submitted to the court an amended summons with additional counts 2, 3, and 4.
Let me see if I have those.
I have a copy here.
Oh, I have it. It's just all clipped together with no note that that should be. So, all right. And before we, okay, that might make more sense. So was he terminated because of the abusive behavior?
That is not correct. He was terminated for non-attendance.
Okay, so I'm going to amend count 1 to read, unless there's an objection, but I think for clarity, it needs to say, on July 21st, 2026, community mental health staff confirmed defendant was terminated from individual therapy due to non-attendance. Any objection?
We would have no objection.
All right, thank you. As to count 2, on or about August 10th, 2026, defendant engaged in assaultive, abusive, threatening, and intimidating behavior toward Demetric Boyd. Count 3, on or about August 10th, 2026, defendant was in possession of Xanax, and I'm assuming that was without a prescription?
That is correct, Your Honor.
So I'm going to add that without a prescription. Any objection to those amendments
No objection.
on behalf of the people?
No, Your Honor.
All right, thank you. Count 4, on or about August 10th, 2026, defendant engaged in assaultive, abusive, threatening, and intimidating behavior toward Isabella Lagana, Isabella Lagana, a protected person through pretrial release order. Is that the extent of the violation, sir?
That is, Your Honor.
And you've reviewed all of those with your client?
I have, Your Honor. I had a conversation with Mr. Thompson. He is prepared to tender to Your Honor a no contest plea to the allegations. The no contest would be based on one, criminal responsibility that he has pending charges on these other files. And two, Your Honor, he admits to relapsing and there is an issue regarding memory.
On behalf of the people, are there other charges?
There are.
So I don't know if even a no contest plea should take place.
Mr. Thompson was charged with a home invasion, first degree assault and battery, habitual force. Home invasion, first degree assault and battery, habitual force. That is set for a probable cause conference on the 20th with a preliminary examination on the 27th.
So if there's a no contest plea to these, are the people going to use that against him in any way? And are there police reports for me to use? And those police reports don't generally come into play in another case, and so I'm a bit hesitant to do that. I think we can get where we probably need to be without dealing with, because we have count 3. Are there charges in regard to possession of drugs?
Not at this time, Your Honor.
Will there be?
Potentially.
Okay.
Potentially maybe added at example. We're not added at the time of charging.
So I think we hold 2, 3, and 4 in abeyance, just precautionary.
I would not.
All right, so we can proceed with count 1.
Yes, sir.
All right. Are you waiving further arraignment?
Yes, sir.
Sir, you're going to plead to count 1, is that correct?
Yes.
And did anyone force, threaten, or coerce you to plead?
No.
Did anyone promise you anything that's causing you to plead?
No, Your Honor.
And you've been satisfied with the representation of your attorney?
Yes.
All right, sir, as to count 1, as amended by this court and stipulated to, on July 21st, 2026, community mental health staff confirmed defendant was terminated from individual therapy due to non-attendance. How do you plead?
Plead guilty, Your Honor.
And sir, you understood the terms and conditions of probation?
Yes, Your Honor.
Probation was to help you so that the behavior that brought you before the court never happened again. And you and I had talked about that, and there were certain conditions that you needed to comply with, and one of them was clearly therapy. So you knew what you were to do, correct?
Yes, Your Honor. I ended up falling back into getting alcohol and doing drugs.
I need you to start over and speak up, sir. We're having volume problems.
I said, unfortunately, I end up drawing back and becoming an alcoholic.
You ended up what?
I said I ended up having alcohol, drinking and having alcohol a lot, and unfortunately getting back into doing drugs and stuff like that.
Unfortunately, what?
Unfortunately, got back to doing drugs, doing methamphetamine.
Unfortunately, got back to doing drugs. Yep.
Yes.
All right.
So I was hoping that some type of way or any type of way that I could get help, get sent to a treatment center.
Any time in the way I could get some help or be put in treatment.
Yes.
Sir, what was going on that pulled you backward?
being able to see my kids has been a big stress on me. Having a hard time finding a job, housing, and currently
Okay.
I've recently ended up getting kicked out of my mom's place or my sister's place at the same time. So basically just on the streets trying to figure out what's going on with my
At his
life.
mom's place and his sister's place at the same time.
Trying to figure out what's going on with myself. So a lot of stress going on and then being bouncing back and forth and stuff like that. Your Honor.
Bouncing back and forth, stuff like that. Okay. Sir. Probation was to help you. It was only for 1 year, and it was to help you in regard to getting back with your children and properly parenting. I ordered parenting classes, cognitive behavioral, individual therapy to get at all of these issues as to why you're drinking, drugging, having explosive anger against the community and your own child. And you did not do what you should have done. I am finding that you are in contempt. You violated probation. And what is the recommendation of? So count one will enter. What's the recommendation from probation? Russell?
Thank you, Your Honor. Yeah, probation had every intention of recommending a revocation of probation at this time. However, with the counts being held in advance, he is only at 3 technical violations. However, I would like to remind the court and make the court aware that the victim, Isabella Lagana, there are other pending probation violations involving that case. There is another felony case for that from an incident on 1/22/2026, where we had been at this court and addressed those violations back in February 26th of 26.
Well, he has 3 technicals, right?
Correct.
So I don't have to keep him on probation, do I?
I was under the impression that he need 4, that was 4 strikes in or out for technicals, but I would defer to the court's discretion. I do feel that revocation of probation is appropriate at this time. He now has 2 different incidents of felonious behavior, assaultive behavior towards the same victim that was already protected under a pretrial release order. In addition, there was a 3rd incident where there was a suspected assault that occurred, but no report was made because there's no injuries and they denied anything had taken place just days before this most recent incident that occurred on 8/10. The defendant has had chronic police contact and chronic issues since being on probation. And even more concerning, he was terminated from the CMH, their individual therapy. And when I talked to his therapist, she had told me that the defendant had asked her to lie to me about his attendance in therapy. Mr. Thompson has not been successful on probation. I don't see realistic rehabilitation goals for him at this time due to lack of engagement. I would recommend that you follow through with your initial sentence. He'll be held in advance of 365 days jail. He would be credit 59 days total as of this date. He had 10 at the time of sentencing, an additional 40 days on his violation in February of this year, and an additional 9 days credit for his current arrest. Thank you.
On behalf of the people?
I would echo very similar sentiments that probation is giving. Mr. Calvin Thompson, also the defendant in this case, also has, as probation stated, a assault with intent to do less than great bodily harm, less than murder or strangulation, a larceny from a person, and a domestic violence that he is already in front of your honor on. That is case number 26-1455-FH. And as probation had stated, the victim on that case, Isabella Lagana, is the now alleged victim in count 4 of this new violation in regards to this new case, which is the home invasion first, that is currently in district court. The people are concerned with Mr. Thompson's continuing behavior in regards to stalking this individual and having continued contact with this individual. And additionally, Your Honor.
And is that, I'm sorry, is that Isabella or somebody else?
No.
Okay.
He's on both cases. And additionally, Your Honor, the violation, the first technical violation of the defendant had back in February of this year was consuming alcohol. It seems like he continues to go back to alcohol, continues to violate these court's orders. And the people are very, very concerned that if Mr. Thompson is released and let out, he's going to be a danger to not only himself, but others, particularly Miss Laguana, as he continues to have alleged threatening and assaultive behavior with her. Thank you.
Is Isabella the mother of the children?
No, Your Honor.
Okay. Who is the mother of the children?
That I'm not certain. She hasn't been involved with this case and hasn't been involved with probation. As far as I know, he hasn't had regular contact with the mother of his children.
Okay.
Thank you, Your Honor. Just as to kind of like square the circle, what we're talking about, MCL 771.4B, MCL 774.4B, parens 1 outlines the requirements as it relates to technical violations and what Your Honor is able to sentence my client to. At a third technical violation, Your Honor, the rule states for third technical violations, jail incarceration for not more than 45 days.
Well, I don't care. Here, like, explain to me this, okay? I don't want to be rude or disrespectful, but those rules are silly to me to begin with, especially with a history like this. Explain this to me. I gave him 365 days that I held in abeyance. That cannot negate this 365 days I sentenced him to, can it, or does it?
Well, I mean, Your Honor, the rule is what the rule is. I understand if Your Honor believes it's silly, but if.
Well, but my 365 days that I imposed are not silly. They are there and to be used at any time as a wake-up call. So I don't think that trumps this unless I have not imposed any jail time. And I gave him, as I do with everyone, and everyone knows it. I know probation always puts like 7 days with 7 days credit. I always negate that. In fact, here it said, you must serve 10 days with credit for 10 days. I wrote in here and ordered 365 days with credit for 10 days and the balance was held. I held that pending his behavior, which has been atrocious. So I do not think that, I think that you are absolutely correct if I would have done what probation wanted me to do, which was 10 days with 10 days. But he has 365 days under my initial order. So argue that.
Well, I mean, if that's how Your Honor does sentencing, I believe Your Honor may have a path, we'll say, to do what Your Honor wants to do. If we're looking back at the original sentence and you're saying the 65 and we're just imposing the original sentence again, then I leave that at Your Honor's discretion. I would just point out, Your Honor, that my client has admitted that he had relapse and he is in need of treatment on this. He told me that he started using alcohol again and that led him using amphetamines again. And if he's using both of those things, we're really not kind of treating the core aspect of what's causing all of these issues. So I would ask Your Honor to consider sending him to treatment, understanding that we may have to serve some sort of balance on this file. But I think ultimately, if we're going to do Mr. Thompson and even like society in general, a service here, it is to treat him on top of incarcerating him. So if Your Honor would, I think probably the most fair of the assessments would be to give him the 45 days as if probation, underneath the guise of what the rules are looking at here, send him to treatment thereafterwards. And then if and when we either adjudicate the rest of these probation violations or when the other case gets adjudicated, then we can deal with all of it then afterwards. So that's what I'd ask Your Honor to consider.
So the problem with doing that is with all these pending charges, he's not eligible to go to treatment. So I can't impose that, which I'm a big believer in rehabilitation, but first and foremost, he did not get himself out of bed to go to the individual therapy and all the other therapy that I ordered. I already ordered all of this. He wasn't interested for various reasons. He couldn't get himself out of bed and found it easier to find help in a bottle and illegal drugs than going to counseling. So I don't know that that would help.
The other thing, Your Honor, is I believe he has a PR bond on the 26-1445 FH cases in front of you. This appears to be an alleged PA 53 violation in regards to that. I'm not sure why that's not also in front of Your Honor right now, but I believe that it also may be appropriate to change the bond in that case given the circumstances here.
All right. Sir, anything else you want me to know?
No, Your Honor, I really believe I need treatment. I'm not doing too well, and I believe treatment will really help me. I'm not talking about outpatient. I believe inpatient. I really believe inpatient treatment do 100% good for me.
I agree, sir, but you have all these other files, and generally, unless there's a plea or some other decision in these files, and there are lots of them that have sprung up, I don't think you're eligible for a bed. I could find you a bed, but I don't think it's going to do any good. So, sir, I am finding that you are a danger to yourself and others. I am finding that you've miserably failed probation, and there is no reason for me to keep you on probation. If I were to look at the Public Act 53 violation, that would yet be another violation. I think we could stack all sorts of violations. So regardless of 774.4B1 and all the other MDOC ridiculous rules that tie my hands, I always order 365 days. This is a 1-year misdemeanor. You failed miserably. And so the best place for you to be is in lockup to think about what your life is going to be like. We can get you treated behind bars. You couldn't get out of bed before. I don't know that anybody in a residential setting is going to get you out of bed either. And many people walk out of residential, even when they're locked down. We have all sorts of problems with that. So, sir, I am imposing my initial sentence for all of these violations, or for this violation and the behavior and the fact that you just have not done anything. You've not succeeded. And I sentenced you October 1st of 2025. And here we are in August. And so we've had what? October, November, December, January, February, March, April, May, June, July. That's 10 months and a half, 10 and a half months, nothing. So you have 365 days jail that I initially imposed. Now you have 59 days credit. While you are incarcerated, you will participate with community mental health treatment. You will complete CATS. You will get your GED. You will attend AA, NACA, any substance abuse treatment they have over there, including anger management, domestic violence, and parenting classes. You're going to take it all, sir. You got a year to do it. There'll be no earned early release, no tether release. You only get your statutory credit. So technically it's less than a year, but you have all these other files to deal with. So, and then this file will be closed in regard to counts 2, 3, and 4, and anything else on this file. I'm simply dismissing them because this file is closed. There'll also be no contact with Isabella Lagana. And furthermore, because you have not availed yourself of treatment, and I find that you're a danger and you have not cared enough about treatment to care about the children that you're sad that you couldn't see, which I allowed you to see once you were in treatment and everybody agreed, but you did nothing toward that. You will also not have any contact with Ariana, Arianna Dassance, Dassance, Quincy Dassance, or Amaya Anna Dassance Thompson. No contact means no contact, no letters, Hallmark cards, phone calls, messages through third parties, smoke signals, carrier pigeon. Don't get creative. There's no contact. Sir,
Except for indefinite?
I can't hear you.
I said for how long, Your Honor?
Well, for the time that you're in jail, unless I receive something from community mental health, therapists, whoever, trained professionals, that contact would be good. You did this to yourself, sir. Whose custody is are the children in?
Mindy Dassett's.
Who is
Mindy
that?
Dassett's. The mother?
The mother?
Yes, Your Honor.
Let me look and see if it's in the report. Okay, so the mother is Mindy, MindyDassance. You'll also not have any contact with her. If she wants contact or needs contact for any reason, she can let us know and we'll figure out if we allow that. You need to
Yes, Your
heal
Honor.
yourself before you re-engage with your family if they want that, and we need to make sure it's safe. You have a lot to gain by getting healthy and clean, and you have a lot to lose by not. So the choice is yours, sir. You need to make better decisions. You should also participate in cognitive behavioral therapy if it's there in the jail. So I've basically given you everything you can do in the jail. Keep busy. Help yourself. It's also going to be meaningful in your other cases. You want to stay in bed in the jail, they're not going to kick you out of bed, but they will tell me, they will tell counsel, and it won't look good for all these multiple pending matters you have. The Public Act 53 violation, was that with Isabella?
Yes, Your Honor.
All right. Well, that can be brought at a different time. It's not appropriately before this court, but I do recognize that with all the multiple things that are going on out there, he is a danger to himself and to others. So, sir, you have 42 days to appeal and to request appellate counsel. I believe the jail has appellate rights there. Counsel, you can also send those to him. Back in COVID, they had them there. I made sure they had them so they could grab them. I don't know if they've continued that.
We will make sure he gets it, Your Honor.
All
In
right.
fact, just for the record, Mr. Thompson actually is scheduled to speak with his attorney on that other file today. And I'm leaving her a note so they can talk about that as well.
I appreciate that. Sir, I'm sure you think this is all happening to you and everybody's mean and all of this, but I'm telling you, this is happening for you. So you once and for all straighten up your life. Get the message that you are a valuable human being, but everybody around you needs to be safe. So this should not define you, and it won't define you if you get better, if you choose to get better, if your choices are better. However, it will define you if you keep on this negative path. Do you understand?
Yes, Your Honor.
We wish you the best, and I hope someday you come back and show me the great things you're doing. If you've done all of this, you certainly are capable of doing good. Just flip the script in your brain and tell yourself you're worthy, you matter, and you're going to do better every single day. That's all for the record.
360 days though?
365 days, you got credit for the 59, and with jail math, that's not a year. It's more like 8 months or so. I don't know. They'll tell you. That's all for the record.
Jacoby or Jacob?
Oh, Judge, Judge, if you don't mind, can you please read my burden of motion?
Yeah, Judge, I think I'll be in agreement with a reset, notwithstanding the emergency motion. I haven't read it myself, but apparently my witnesses think that a subpoena is optional, and my witnesses think a subpoena is optional. So I'm going to address that. I'm going to deal with that.
Judge, but I would still need the emergency motion because the thing is, Judge, I'm asking that you to order the state. I know you haven't read it, so if you can preview it somewhere.
I'll peruse it.
Yeah, peruse it. I apologize.
That's okay. It's a P word.
If you look at the timeline, I spelled the timeline out first, and I did give Mr. Coleman a copy. I was served with that motion on the 13th. I requested discovery on the 15th of this year.
This month?
This month.
Okay.
August of 2026. At 2 p.m., I got the police report on the 17th. I got some supplemental materials. Yes. When I did get the police report from Mr. Coleman, it was several things in that police report that came to mind. One, his complainant
at least in the police report, did not want to pursue charges, but then also it mentions about an Axon body camera that was also activated. So in preparation for this particular hearing, one, he has a complainant that didn't want to press charges. Two, at least according to his police report, there were no visible injuries. And three, according to his police report, there was body cameras. So if you look at the emergency request that I'm asking you to order from the state, every body worn camera, surveillance, cell phone, any kind of media recording relating to that case, which I don't have, any 911 calls, dispatch audio related to that, I do not have. Medical, Mr. Coleman did provide me with, I think, 7 pages, if I'm not mistaken, 6. I don't want to misspeak, but he did send me an email of a police report, but I don't have any medical information, et cetera, et cetera. I don't have other police officers' offense reports. I don't have any exhibits that he planned to use. And again, since this is a motion to increase his bond, the Texas rules of evidence supply, those police reports will be purely hearsay, and I have a right to confront those people. So as an emergency matter, in response to his motion to increase bond, I think the court has already seen my emergency response.
Let me ask you, what did you say about the victims didn't want to pursue it?
Yeah, I got a copy of it, in his police report.
Oh, okay.
Yeah, I got a copy of it. I can let you read it yourself.
What?
In the police report that he provided, I think Mr. Coleman emailed me a copy of the police report, and I got it right
Well,
here.
just summarize it.
Right. It specifically in the police report that he said, he emailed me, it said,
Judge,
either
I'm
party.
sorry to interrupt counsel. However, he can't use the rule against hearsay as both a shield
I know, I
and
just-
sword. He's saying I can't use hearsay, but now he's recounting hearsay.
I'm curious. I'm gonna,
Well, I mean,
let him read
Yes, sir.
what
Just
he says.
just pointing it
I'm
out.
curious.
Just making an observation.
Just go ahead.
Okay.
Complete.
What I'm reading is word for word, Judge. I'm not making this up word
go
for
ahead.
word. Neither party wished to file charges and were provided with a witness statement, case card, and victim's assistance packet. That's I'm reading that word for word. Neither party wished to file charges, and that was neither him nor the lady. And I'm reading that word for word.
Hold on. Okay, I'm
Neither
stopping you
party
there.
wished to
Hold on.
file. Huh?
There's 3 cases.
Correct.
Yes, sir.
These are operating a motor vehicle in a public place while intoxicated.
Yes, sir.
Yes, sir.
Who's deciding whether they should be charged or not?
No,
The general public,
No.
or is it the police who stopped it?
Well, Judge,
No, that's not that.
I think we both agree that there are the 3 underlying pending felony DWIs. What I'm alleging is the basis or part of the basis for the motion to increase the bond is the new charge of an assault, and that's what he's speaking to.
Correct.
You talk about an assault. Is that filed?
No, it's unfiled.
It's been, and to my understanding, from what I read to you word for word on the underlying case,
Okay.
has not been, she don't want to cooperate. She don't want to press charges. And I read it word for word out of the police report.
Oh, okay.
The lady does not want to press charges.
Okay. But here are the 3 charges that she doesn't have.
She had nothing to do with those. You're right.
These are 3 felony convictions. These are 30 years.
Right.
30 years in
Correct.
prison, sir. So these are all 3 felonies. One's bad enough. The 1, 2, 3, operating a motor vehicle in a public place while intoxicated. This other matter on an assault, I don't have information about, and the state is I guess has information or is gathering it, but here's how much time do you need?
Judge, I would ask that you grant my motion.
How much time do you need?
I would say at least 3, because if you grant my motion to compel, I say at least 3 to 4 weeks, because
You have 3 weeks. You'll have 3 weeks. Here's the deal, though. Once again, if I find out that you've even contacted any of these people involved here, you won't have a bond. You'll sit it out in jail. Plus, I'm going to ask them to look into further charges on attempting to interfere with an investigation or influence testimony. Let me just find out, and it'll be so fast, it'll make your head swing, okay? Because that doesn't happen. That's not proper. It's illegal. You don't manipulate the system. It works on facts and the law, not behind the scenes manipulation. That's inappropriate. That's on television. This is real world here. This is the way it should be under rule of law. But I'm just warning, I will, it will be a stern result. And it will be harsh for everybody involved if I find out otherwise. But I'm gonna give you 3 weeks.
And Judge, are you ordering to say that, in my motion to compel?
There's no need for an order. I'll turn over.
He said he'll turn it over.
Hold on.
Oh, my bad.
Everybody, only one person can speak at one time or she can't do her job.
Yes, sir.
This isn't a shout fest.
Yes, sir.
Yes, sir.
And when the court speaks, everybody's got to stop.
Yes, sir.
My bad. My bad. Look.
Everybody gets a fair opportunity to speak, but she's got to do her job,
That's true.
or else everyone who prevents her from doing her job, according to the Court of Criminal Appeals, will be in trouble. I don't want to be in front of them not following the rule. Let's everybody do it in a civil way. You get to speak, you get to speak, but not over each other.
Yes, sir.
All right. What is it you're asking for?
No, I trust Mr. Foley.
Yeah,
I got a relationship with him, so
I'll
no,
turn
you
it.
fine.
I'll turn over everything.
Yeah,
All
we
right.
got a good relationship. So that's not
3 weeks.
Thank you, Judge. I appreciate you. Mr. Foley.
Yes, sir.
On Mr. Taylor, though, that is a plea, so let me get him signed up.
All right, because I've got a murder trial to get into.
Okay, he's here with his family and he's back there. Let me get his paperwork. I think I got that with Mr. Ham. He's filling in for,
Judge. One other thing, Judge, would you consider a drug test, given the nature of the underlying charges, the 3 DWIs?
Say that again.
Consider a drug test for this defendant, given the underlying offenses.
What was the reason for the intoxication?
one of them was THC.
Yeah, one of them was THC. Judge, in cause number ending in 0501, it was a lab that indicated ethanol or alcohol in.
So we got drugs in one case,
It,
alcohol in another.
Yes, yes,
What's the third?
0367, it was marijuana.
What were the readings in the two alcohol?
Oh,
Have a
and
seat right over there, sir.
There-
We're gonna test you.
there was also marijuana in the last case as well, the one ending in 08.
Hey, Langston, there was marijuana in 2 cases.
2 of the 3.
Right, that's correct.
Okay.
All of this had accurate on that. I think 2 of the
What was-
cases had
what was
marijuana
the
and one of them
alcohol?
had alcohol. I think only one had alcohol.
It was 0.105 in the alcohol only case. And I would point out, Judge, in the, in 0501, he allegedly passed out in a drive-through at Jack Box, and cause number,
Well, were there a lot of people in the drive-through?
I don't know, Judge, but
Okay.
in 0840, he actually, no. There was an accident in,
The drive-through?
no, this was a separate case. In 0367, there was an accident. I don't want to misspeak, Judge. Let's see here. One of these things that ended in an accident. Now, I want to make sure I get it right. In 0367, he ended up allegedly striking a parked vehicle, flipping his vehicle. So just to give the court some background, some context.
Okay.
But he is wearing a drug patch on.
Okay. He's gonna get tested.
All right,
All right.
let me get, I'm
You'd
signing.
be surprised how those drug patches sometimes fall off and we lose track of them. And it's a miraculous event that occurs too often. That's why we do what we do here. So we'll get it passed and we'll know for sure, but he'll continue to have the drug patch. Don't lose the drug patches. Whenever it falls off, quotes, it falls off before the test is done. That's always suspicious and that gets the person in trouble.
I'm taking a pill right now.
Thank you. All right. We're in short recess. All right. Mr. Garrett, you've got alcohol in it. I need this file.
Hold on.
He's got alcohol in his system.
Judge, I believe that's a violation of pretrial release, y'all.
Judge,
Okay.
a quick, just a request. Since you granted a continuance on his motion to increase function, and he did, I understand that he tested positive for the alcohol. I was gonna ask that before you increase his bond, that we can put this on the same date as the continuance being granted.
No way.
State's opposed.
No, it's not anything, you're doing what you can, but I'm gonna treat him like everybody else. I'm not letting him walk out of here with alcohol. because I can't stop him from jumping into a car and doing something crazy and hurting somebody. And we're not in control. That's why these orders were placed.
Let me get,
Hold on.
let me get the box. And the only reason I had to ask that.
Yeah, I understand.
And I continue, and I was gonna ask you, put them on the same
No,
thing.
but we can't just let him walk out here because he's in harm's way. And if he drove up here, he may have operated a motor vehicle in a public place while intoxicated. I don't know, but one of all bond conditions are number one, don't commit a crime. And then when it's involving a motor vehicle and you're charged with driving, well, then you are subject to the requirement not to operate a motor vehicle in a public place with any alcohol.
It's not blocked.
We should be done with a lot.
They're going to. They're in section.
The magistrate. When you were arrested and you were brought before the judge, they ask you, do you have a history of drug or alcohol abuse? And you denied it. And does the inmate seem to be under the influence of alcohol or drugs? And you were arrested for this driving while intoxicated. And anyway, one of the conditions is do not operate a motor vehicle in a public place while intoxicated, but also I think there's something about no alcohol at all.
And Judge, I'm sorry to interrupt the court, but even if there's not, my understanding of Article 17.15 of the Code of Criminal Procedure is that one of the factors the court can consider is so-called aggravating factors in setting a bond. And I certainly would argue that if someone is facing 3 felony DWIs and they show up to court with alcohol in their system, that constitutes an aggravated.
You drove up here, didn't you?
No,
You drove up. His dad was right.
Even more than that, Judge.
Okay.
Even more than that, an aggravating factor that I would argue is that if you're facing 3 felony DWIs, you should abstain or not have alcohol in your system, particularly if you're showing up for court.
I guess just a response to that is that argument looks against Mr. Coleman. Let's give the underlying argument. If the underlying offense is a DWI, the danger to the community is him driving in those 3 DWIs. In this case, if he showed up with alcohol,
if there's an order that says don't consume any alcohol, that's pretty clear.
Right, and I think that's what you're
just
looking for.
because you're drinking at home and not behind the wheel of a car, caught behind the wheel of your car. That doesn't help the general public, because how do you stop somebody from hopping into a car if they want to? And you don't know. You jump in a car and unless you have a bunch of people staring at the car 24 hours a day and watching it, we got to trust that. But it is always do not consume any alcohol if it's a DWI, and the same way with drugs. It's based upon drugs, period.
The bond condition.
And the thing is the people, I can't stop him from jumping in a car if he wants to. That's why if he's going to jump into a car, he needs to be sober, or in these cases, don't consume any alcohol. But I guess it's going to find the order that says that. That's what's important, because I can enforce an order. but it's got alcohol in the system. If the state can find an order.
Part of the general order, Judge.
Where?
I believe it is.
Pull it out for me. I don't have it in my pocket.
And while he's looking for the judge again, I would reiterate that the court has discretion under chapter article 117.15 to increase a bond if there are certain aggravating factors, and I would submit that this is an aggravating factor, notwithstanding whether or not there was a previous order or bond condition.
Judge, that's not the law. Like in his motion that he filed, it says any aggravating factors in the charged offense. He's not referring to the charged offense. So what he's saying is not accurate. The charged offense is those three underlying cases. There's not aggravating factors in those three underlying cases. What he's saying is that my client tested positive for alcohol today in a car in which he's not driving. So I think what Mr. Coleman is absolutely wrong. And I'm quoting Mr. Coleman from his own motion. It says any aggravating factors in the charged offense. Mr. Coleman does not have that. So I think Mr. Coleman is absolutely inaccurate in his position. He's wrong. I think he's wrong in that.
Judge, I'll concede that's what the motion says. That list of factors that are cited in my motion is not an exhaustive list. It's a non-exhaustive list. It is some of the things that the court can consider, but it is not limited to that.
It's your general order, Judge. Number 2 says that you're testing for alcohol.
Well, I know that's what it says, but it doesn't say, it says submit to testing.
Correct.
That's what we did. He did that. What did he violate from submit to testing? The question is, I'm looking for the order that states you cannot consume any alcohol while the case is pending. Y'all find that for me.
Yes, sir.
That's what I want.
And Judge, not at the risk of being redundant and beating a dead horse, I'd like to direct the court to Metter v. State. It's a 14th district opinion, 14th Court of Appeals opinion from 1989. It says, and I quote, "There is no exact standard for determining good and sufficient cause for increasing bail." It also, there's another companion opinion, the Miller v. State opinion, again out of the 14th Court of Appeals, 1993.
Well, but I know what that says, but also I'm not going to make a change for whim, due to whim. I'm going to do it for a responsible basis. I'm not going to change just for the sake of change. And that doesn't make any sense. Of course, where's the fairness?
Right. And
where's the fairness in that?
Those cases that he's citing isn't mandatory authority for you. He's saying something out of the 14th Court of Appeals, right? He's not saying out of the Court of Criminal Appeals, and he's not saying anything out of the 9th Circuit, which is us. So that's not even mandatory authority.
I just made a statement that takes care of.
Thank you, Judge.
Yeah.
So I'm just saying that's not mandatory authority for you. He's not giving you mandatory authority at all.
Where the order is.
Judge, I'm going to weigh in just because Officer.
I'm asking, where's my order that states thou shalt not consume alcohol while this case is pending?
I believe it's properly implied that with the number 2 language underneath the general order, that if we require defendants to submit to testing for drugs and alcohol, that it is understood you're not to use those items. The only matter in this order that is clarified further is THC, because of all the subsequent claims that have been made by defendants and defense attorneys about THC. But it is illegal to use drugs. It is inappropriate to use alcohol when you're on bond specifically for a DWI. And I stand by the fact that we don't need an order specifically here that says you cannot drink when you've got 3 DWIs.
And Judge, if you don't mind, Mr. Adams, Judge, and if I could follow up on that, the case law clearly says in chapter 17.15 of the Code of Procedures clearly says it's not whim, Judge. You can find that there's good and sufficient cause given the circumstances, Judge. And I'm sorry, I don't mean to go on and on.
Judge, Mr. Ham didn't cite any authorities for his position.
Once again,
Mr. Ham did not.
Once again,
in interpretation.
Once again,
I think he's wrong.
show me where somebody charged with a DWI, unless they're ordered directly. And I don't drink alcohol, so I'm not I'm not, and mad people are my favorite people because they save lives.
Judge, I believe it's
But where
implied.
is-
If it's not, then we certainly need to start ordering that everybody not drink alcohol.
But I have.
When they have DWIs, the clerk tells me that with his third DWI that came up, that he was ordered to get a scram device. And if he's not wearing that
Judge, neither
as
Mr.
well,
Long, Mr. Coleman can answer the question that you asked. Neither one of them can. They keep, Mr. Ham keep on to talk about implied.
All right, I'm out. I've heard everybody's contention. Is there a scram device that was ordered? If he doesn't have it, then he failed an order. Number one, if you want to, but we can bring those things up in the middle of this conversation. He's got to follow the orders, whatever they are. I'm looking for the order that says don't consume any alcohol or drugs. That's the important thing for this case, because technically you're charged with the law allows people at their home to do things lawfully if they wish. And unless they've been ordered not to drink any alcohol, then they can consume alcohol. That's a general rule against that.
And I think you're right with optimistic opinions because they cannot cite neither willing to do. And they can talk about them about it. How they can talk about it. The fairness, my mind has right constitutionally to be given notice of these conditions. And Mr. Ham can talk about implied all he wants to. He's not given the specific, and they can't answer your question. Neither one of them can answer your question. Neither Coleman or Ham. So I'm asking, Judge, since neither one of them can directly answer your question.
I'm giving them a chance to look and find.
Judge, just to be clear, this my position. Notwithstanding the argument about there being some implied basis, my argument is that Article 17.15 of the Code of Criminal Procedure gives you the authority to find sufficient cause, good and sufficient cause.
In my response, Judge, his very motion didn't say that. It is towards the factors that he listed for aggravating factor number 7. And I read from his motion word for word. His motion doesn't even
This court ordered on May 13th, 2026, that he have a scram device. Where is it? It's August. This was 5/13. July. You don't have a scram device, do you? I ordered this on May 13th.
Judge, the state would move that the court hold the defendant in contempt for not following that order to procure the scram device.
You do have.
All right.
He's understanding what
he didn't have a scram device. That's what the order was.
Patching and the scram was ordered.
Yeah,
by the
I got two.
judge.
He has two things he's got to do: the scram, the patch, and the scram. He doesn't have a scram device. I ordered him to have a scram device. He didn't have it.
That's what.
And it's been 3 months.
That's what I guess.
You're ordered to have a scram device. You have to have that. That's not a scram device. It's something that works on being allowed to test you before you jump into a car and start a 4,000-pound missile. You don't have it. You got to get that.
So the no scram is the one he wears on him.
Oh, yeah, here, it's,
all time.
yeah, it's, and you have to have an interlock device. That's for that. A scram device is something that it's on your leg and it tests for alcohol all the time. But you have to have a scram device.
I think when he went to probation, they put the patch, they put that on him.
Yeah, they put that on me.
I ordered a scram device. I don't care what they did. I ordered a scram device. I don't care what they did. That's your responsibility. My order is you have to follow the order. Whatever somebody else did, they didn't. I didn't order that. They got to follow the order. You have to follow the order too. You have to have a scram device, sir. And you tested positive.
Just ordered on that last case, Judge. It was
The scram device keeps us so that we know before you come to court that you have failed the test. But you have to have that.
You can tell them what you.
Anyway, that's what that is. You have to have that.
So when I went to the bonds people, what did they?
That's between you and them. I make the order and then, but it's ordered, you and your, that's why you have an attorney. You have to follow the court's orders. I ordered that on May 13th, 2026. That's what the court directive, that's what it shows. And that would have been, I think the scram can detect it more quickly than the patch. The patch, you have to take the patch off and then go get it tested. Scram, I think, works differently than that. Isn't that right? The way the scram works?
Sorry, what did you say, Your Honor?
Do you know how the scram works procedurally?
I believe the scram only tested for alcohol. And it's stuck to the body like an ankle monitor, and it tests through his sweat. I believe the same way it
Okay,
does.
and then how is the test reported to an authority to say, uh-oh, there's a red flag here?
Like Johnny's, they monitor those as well, the same as a drug patch.
Okay, how do they monitor them?
I believe reports come in over time.
Okay, but it's not immediate.
It's on the jail screen.
It takes a delay.
I believe if there's a
I don't know.
I can find that information out for you if you want me to. I can step back.
Well, I'd like to know
Okay.
procedurally how it works. A scram device was ordered. I don't understand.
The magistrate's paperwork, Judge. Oh, here it is. Hold on, let me find it.
When the magistrate orders in the court reviews and changes it if it's necessary. I wouldn't have changed something like that. And it would have just been, I would have accepted as that's good for me. I don't need to change anything, but I would have affirmed it. But there's no written thing that you do. I just look at them and say, that's what I need to do. But I'm looking at a document that, and it works. It's an order of a court. So you still have to follow that. And if you don't, you're subject to being held in contempt. Also, your bond could be affected if you don't follow those.
And that was what I was about to say, Judge, is that I would add that this is sufficient, borrowing that language 17.15. The court to increase the defendant's
Well, Judge, I would ask that back on that motion to confirm that you granted that we hold that on that date that he's gonna argue with the lady.
You went to the in front of the arraigning judge. It's right here, $70,000 bond with scram device and drug patch for the 3rd degree.
It says 70,000. You have a $70,000 bond? Is that right?
I think that's one of those.
That's one of them.
And then you got a $2,500 bond on a misdemeanor.
Correct. That's
For
correct.
a class A misdemeanor resisting a search or
That's correct.
arrest.
That's correct.
Okay, and he also has a $35,000 bond on each of those 2 other pending DWIs.
That's correct.
See, the reason all of this is also a concern is because
Okay.
Mr. Garrett starts off this.
Hey, Judge, it looks like we also ordered it as well on our warrant, and the arraigning judge just followed through with that.
So the monitors, drugs, scram monitors.
Yeah, this was all after the third case was indicted. He was indicted on March 26th of 2025 in 25 CR 367 for an event that occurred on September 23rd, 2023, which was a year and a half before of a DWI. And at that time, it was a DWI third because of the 2 prior convictions plus the previous conviction in 2015 for burglary of a habitation out of this court that he was convicted of made him a second-degree felon. But so on September 23rd was his first DWI out of this group of 2023. Then a year later, he commits another DWI third on September 21st, 2024. But what's interesting is they're not alleging on that subsequent, the prior conviction.
I'll do a notice. I'll file a notice. A notice of enhancement.
That would enhance it to a second-degree felony.
I'll file a notice.
So that's a year later, and then September, October, November, December. On December 31st, 3 months after the second DWI, he's got his third DWI. And the two prior DWI convictions are in there that makes it a third, but also now we have two burglary of habitation convictions out of this criminal district court on June 16, 2017. So this third one is enhanced to a second-degree felony, which makes it the 50 years that he's looking at on all of these, the way they're indicted. But the problem is the consistency of the DWIs caused us, after that third one, to, on this warrant, the court issued from the indictment of the third indictment, 501. He is at large without a proper bond, I stated, must have scram device and a drug patch as a condition of bond. I have him on both. And he doesn't have the scram device. I ordered that in May of this year. You're going to be taken into custody until you can get it. You're going to be arrested also. You have to follow the rules. What is his bond?
Judge, I am showing that in the case ending in 0367, he has a bond of 70. No, excuse me. In the one ending in 0501, $70,000 bond.
Okay.
In 840, he has 35,000. And in 0367, he has 35,000.
Okay. I ordered this in a 501. Your bond is revoked. It's doubled. It's doubled. Yeah, and you have to have an interval. The device that the court ordered, the scram device. And here you are coming up, and we're testing positive, which is to prevent you from using alcohol. And because you don't have it, we're unable to test unless we're coming to test you when you show up for court. And that's not the way it's going to work. So until you can follow those terms and those conditions of bond that I am increasing, you're in custody because you're continuing to consume alcohol. Fix that, sir. Work with him. He's a smart man. And you need to deal with this in a more responsible fashion. You got a problem. And your problems are exacerbated because you're jumping into 4,000-pound missiles and you're putting everybody else in harm's way, as well as yourself.
Just as a procedural question, I know that we've increased, or the court has increased the bond and doubled the bond in that particular case you just mentioned.
And I caught him with, he had an order that he hadn't followed since May.
My next question is, I know you granted my continuance on the state's motion to increase bond as far as with that lady is concerned. Well, now since this case has increased, are we still going with that, or is that now? I mean, how's that going to be?
No, my orders, because of the immediacy of this problem and the fact that he's coming up here and testing positive for something that was supposed to be a deterrent by the use of the scram device that he's not using in the court's order. He's got to start following the order, or else I'm putting everybody else in harm's way, including him. But you need to fix that. Deal with it responsibly. Anyway, then what's the next event?
I guess, I mean,
I'm not withdrawing my motion, Kate. I may reevaluate whether or not I will withdraw my motion, but I'm not at this point willing to pull back my motion. It's been reset.
I want to review in 2 weeks,
Thank you.
please, of what direction we're going to head in on all 3 of these thorn cases, one way or the other, okay? So I know, and then.
I'm good, Jeff.
Okay, all right.
All right, Marvin Watts.
Marvin, what?
I want my voice back. I want my voice back. I promise I have not picked up smoking cigars.
At least they don't have snow.
Good morning, sir. You're Marvin Watts.
Yes, ma'am.
And Mr. Watts is here in cause number 25 DCCR 1918 and 26 DCCR 0946. Each of those cases previously in court entered pleas of guilty, and each of them to the first-degree felony offenses of aggravated robbery. The agreements were per cap of 17 years in the institutional division on each of those. I've received the pre-sentence report. Have you both had an opportunity to review the report?
We have, Your Honor.
I have, Judge. Any additions or corrections?
I'm aware, Judge.
Yes, Judge, the state would like to call Detective Josh Jackson, please.
Detective Jackson? If you'll just kind of slide over a little bit, sir. Right there's fine. Good morning, sir. Sorry I had to wait a little bit. If you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Ms. Malfino?
Thank you, Judge. As the court has already done, would you please take judicial notice of the PSI? I say that specifically towards Detective Jackson's detailed statement therein. And I would just add a little bit of subsequent testimony to that.
Sure.
Would you please state your name for the record?
Joshua Jackson,
And how are you employed?
a detective with Beaumont Police Department.
And as a detective with BPD, is it your duty to investigate violent crimes such as homicide, aggravated robbery, et cetera?
It is.
And did you have a chance to investigate an aggravated robbery that occurred in October of 2025 at the Dollar General on Highland?
Yes.
And did you later learn that that aggravated robbery went hand in hand, for lack of a better term, with an aggravated robbery that had occurred at Dollar General in September, the Express Mart in October?
That's correct.
So within a 1 month time period, there had been 2 aggravated robberies of stores located here in Beaumont, relatively close together.
That's correct.
All this occurred in Jefferson County.
Yes.
And can you describe for the court, you have elaborated in the pre-sentence investigation report, your thoughts a little bit, and obviously the court is aware of the nature of the offense, et cetera. A little bit more about your thoughts for the sentencing hearing before we get to the video.
So, both of these cases involve 2 guys that go into a store, one during daylight hours, another one during nighttime hours. Both victimizing a clerk that's there just trying to do her job. There's no glass barrier on either of these stores. These 2 guys walk in there, hold the clerk up in each of these instances, and proceed to rob the clerk for, at least in mine, money and some cigarettes. And for this to happen in daylight hours or nighttime hours to somebody that's just trying to go to work isn't right. I mean, you don't go to work expecting to get robbed when you potentially have family at home, and during either of these robberies, something tragic could happen.
And Detective Jackson, I think it goes without saying, from both the perspective of the state and the court, but from your perspective as a detective, is violent crime involving firearms and youthful offenders here in Beaumont something that has just become extremely prevalent, unfortunately.
Absolutely.
And is it something that you continue to investigate on a daily basis?
That's correct.
Do you think it would be helpful for the court to view, if you would, Judge, outside of the cameras due to the sensitive nature of the complainant in the case and her identity, the video from the incident in September at the Dollar General?
Yeah, so there's two videos with just the Dollar General on this one that I brought with different angles. It's just giving an idea of kind of what happened to at least the Dollar General one. There's a lot that it's not going to show, which is the aftermath of it and speaking to the clerk and the terror and how she felt. Of course, that's all in the whole case, but at least these two videos will give you a sense of kind of what happened during that day.
Okay. So you want me to just put them here? I mean, I can turn this off, or I can just put them
Just
possibly on my computer and just watch it here myself.
That'd be fine. I did not mark them, Judge, because I believe Detective Jackson
That's the only thing that's on there.
would need them back for future investigation if the court would allow, but if not, I can make a copy for the court.
I have no objection, Judge.
Okay.
To you just watching it. I've talked to Ms. Malvino about it.
May I continue?
Yes, ma'am.
Detective Jackson, obviously the court has taken note of your statement in the PSI, but is there anything additional that you would like to add for the record with respect to the sentencing you would like to see the court impose?
No, I think what I wanted to convey is mainly in that email that I sent.
Thank you. I have no further questions.
Thank you. Any questions?
No questions.
Thank you very much for being here, Detective. I appreciate you. Any other witnesses?
No, Judge, just a couple comments if I may.
Sure, go ahead.
Obviously, it asked the court to take everything into account, the fact that there are two aggravating offenses. Obviously, you are aware of the prevalence of these type of offenses in Beaumont involving young offender with firearms, innocent victims in this type of a case. Officer Riley's comments, I think, are also important, Judge. He's a very detailed PSI writer, and his caution against leniency the state would concur with. In addition to the jail incidents, which show the court, as you're aware, that Mr. Watts cannot behave while in custody, so therefore what leads us to believe that he would behave while on probation. Based on those, Judge, I would concur with the offer of Mr. Nichols at 17 and ask the court for 17 years in each case.
Thank you, Ms. Malfino. Mr. Parker, you may proceed.
Your Honor, in regard to the write-ups, I've talked to him about those. Those happened prior to the his PSI, and that was when he was in maximum security. And from what I understand, it's a lot harder to not get in trouble there because of who you're around. But nevertheless, he has no juvenile record that I'm aware of. He has no adult history that I'm aware of. These are the only two cases that he's ever had any issues with. I agree, they're serious offenses. He understands that. He's told me today that, you know, if I could apologize to people, I would. He was encouraged by somebody older than him. I believe it was probably his father, so it was. And he's asking the court to give him probation. He would like to address the court, Judge.
Go ahead.
No, I apologize for all my actions, ma'am. Honestly, I regret them. I really do, ma'am. Like my attorney said, if I had a chance to apologize to that woman, I would. And ma'am, those write-ups were while I was in maximum security, ma'am. I was not supposed to be in max. I was there because my shoulder popped out of place. And all of those offenses were like, really some of them, like certain ones I do not understand how they were just.
I'm a whole lot less worried about that than what you were doing when you were out.
But honestly, on that comment, I do apologize to that woman and for everything that I've done, man. I regret it very much. It's not just right there, really. Like, you sit on my mind daily, man, honestly. And I really feel like, you know, if I did this, my standing for something.
I appreciate you saying that. I hope that you're sincere. No matter what happens today, you have an ability at your age to change your life and do better things. Unfortunately, I tend to believe that sometimes people are sorry because they got caught, not because really of what they did. I don't disagree with Mr. Parker that looks like your dad's the one that's encouraging you to go out and do this crap. So, but that, all that being said, 2 times within a month, hoodies, mask, gloves, a pistol, another gun that has some kind of, I don't even know what it's called.
Solitary.
No, it was the circle thing that has a bunch of,
Drum magazine.
thank you, drum magazine.
Honestly, I don't know nothing about it. Like, I mean, like you said, I'm be honest with you, man. It was my father. Like, but I did not have no intentions on doing no crime before my father showed up, man. Honestly, I didn't know nothing about how to rob a store, to do nothing with a store, anything like that. So, like,
Well, you went all in, didn't you?
I did.
And Tara, I mean, y'all didn't just walk in and take it. You got to grab her. You got to pull her around. You got to show that you're a man. Somebody did. While the other, so that means you were the one holding the gun with the drum, because the one that had the pistol is the one that was pulling her around. Okay. At this time, I'm going to, Mr. Watts, find in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 25, DCCR 1918, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you to a term of 17 years in the Institutional Division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon in that case, and you will receive credit on it for any time that you've been in custody that the law gives you the right to receive. In clause number 26, DCCR 0946, also find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you to a term of 17 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will also be an affirmative finding of a deadly weapon in that case as well. These cases will run concurrently, which means together at the same time. I'm handing you in each of your cases the trial court certification that shows these were agreements that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Again, you're young. You're going to go to prison, obviously, for some amount of time. It's going to be up to you to do something different or not when you get out. All right. You can go back with the bailiff. Thank you. Jimmy Couch, the Senate. Jimmy Couch.
Morning, Your Honor.
Good morning. You're Jimmy Couch.
Yes, ma'am.
And this is cause number 26, DCCR 0328. Mr. Couch was previously in court, entered a plea of guilty to the lesser offense of a third-degree felony attempt to commit burglary of a habitation. I've received the pre-sentence report. Have you both had an opportunity to review the report?
We have, Your Honor.
I have, Judge. Are there any additions? Excuse me, additions or corrections?
No additions or corrections, Judge, just comments whenever the judge would.
Okay. Anything, Ms. Malfino?
Judge, I would just like to clarify for the court that the offer of the attempt to commit was made based on my review of the facts. I think it was more appropriate to the facts of the case that it be an attempt. It was not an attempt, no pun intended, to lessen his culpability or anything of that nature. I just think that fit the facts better and was a more appropriate plea. Ask the court to take notice of the PSI, and also for some very brief comments. If the court would find it helpful, I would like to call Mr. Couch's wife, ex-wife, Allison Couch, just to let the court know some things about how strongly she's going to ask the court for safety, and the state's going to ask for safety in this case. And I think it would just help give you, if you
That's
feel like you
agreed
need
though, right?
Safety was not agreed, Judge.
No, ma'am.
Not agreed.
Oh, safety's happening.
Ma'am?
If I give you probation, then safety is going to be a condition of that probation. End of
ma'am.
story. So, I mean, either here's the thing, Mr. Couch, conditions of probation
Yes.
are up to the court, 100%.
Okay.
So even if that had not been part of your agreement, it doesn't invalidate your agreement, because I can impose any conditions that I think would be either helpful or necessary to make sure that everybody that's on a probation has the best possible chance of success, and that everybody else out there is safe and secure as we can make them. And so if I follow this agreement, it is going to be with safety based on I've got the, her statements and thank you for being here, ma'am. I've got the statements she has here and I appreciate that she's here in person as well. That means a lot. If there's something that's not in here, we'll take judicial notice of, her statements as well as the, probation reports statements with regard to substance abuse history and the fact that they believe that he needs substance abuse help, but he does not.
Do I get to make a statement?
Sure.
Your Honor, I don't do drugs. I haven't done drugs since I was a stupid kid, 20 years old. I don't do any drugs whatsoever.
Well, it's not just about drugs, it's about alcohol as well.
And I don't have an alcohol problem, Your Honor. I might drink a beer or two a week. That's it. I don't have any alcohol problem. I mean, I don't understand. I've already lost 6 months of my life and I have serious lung disease that I have to have another PET scan and another biopsy because the spot on my lungs is growing. I've coughed up blood 4 times in the last 3 months, been in jail. They will not give me my medications or my lung
What?
treatment.
Maybe you shouldn't have gone and committed this offense.
Your Honor,
Hang on, listen.
I
Okay, just hang on. I understand some medical issues but that's not what's going to go into completely any decision that I make. Okay, so just hang on a second. Mr. Rojas?
Judge, I would just point out that at least from his, whatever he self-reported to the probation department, looks like the last time he used any drugs was 2023, and that he tells me that was prescribed from a surgery he had.
Yeah, that's my surgery.
And the last time he used alcohol was August of 2025, and he was out on bond until June of this year. So if that's true, it would tend to show that he didn't have an alcohol problem.
If your witness is willing to come testify under oath, then that would be probably good.
Thank you, Judge. Ms. Couch. Maiden name, Byron.
Okay. Go on.
Don't interrupt.
Okay.
Good morning, ma'am.
Good morning.
If you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Ms. Malfino?
Ms. Couch, would you please state your full legal name for the record, please?
Allison Couch.
And how do you know the defendant, Jimmy Couch?
He's my ex-husband.
Okay. Can you tell the court, obviously you are aware that we're here for a sentencing hearing today, correct? And is it correct that you and I have kept in pretty constant communication with respect to this offense? And you filled me in on a lot about the defendant, his history, his substance abuse history that may not be included just with respect to this offense, correct?
That's correct.
And do you think it would be helpful to Judge West to hear just a very little bit about that, especially after you've seen how the defendant has acted this morning, which was obviously a concern of all of ours, correct? That he continues to minimize, he distances himself from the severity of his alcoholism or substance abuse problem. Would you think?
He's mouthing something.
Look at me. You turn to, actually do this. Turn around and look at that wall. Go ahead, ma'am.
I'm sorry, Judge. Do you think it would be helpful for the court, from your perspective, to know just a little bit more about Mr. Couch and what you want for him with respect to his trying to get help and why you and I discussed at length this offer and a chance at probation to try to get him the substance abuse help?
The whole point in this and me sticking this through is to get him the help he needs. He's a serious alcoholic. His family knows it. His friends know it. I lived with it. It's terrible. And we love him, but we want him to get well. He hasn't been able to do it on his own. And this is our last resort, is basically what this is.
It's either this or prison, right?
Yes.
Or
he'll kill somebody while he's out there driving drunk.
And do you believe this with everything you know about the defendant?
Everything. I've experienced a lot with Jimmy. It's been a very hard experience. But I do have a lot of love and heart and care for him in my heart to see him through this. I want to see him get help.
And is that in fact why you are asking the court to consider allowing him to serve this probation, but imposing safety, which we have discussed is the most stringent lockdown treatment program with all of the aftercare conditions, et cetera, with a condition that afterwards he have no contact with you? I know we had discussed some things with concern to his sister's concerned she may come there, you're concerned he may come to you, and he's got to learn how to stand on his own 2 feet and not bring his problems back into everyone else's life. You're asking Joe to do that.
Well, we do know that he has nowhere to live. He has nowhere to go. He has I mean, the family knows what's going on. Nobody can take him at this point. But we don't want to see him not have communication with family. We feel like that's part of the healing that he's going to go through. But we do feel that he's going to have to be forced to do this because he has failed on his own prior to this. He didn't complete a rehab he did before. And it's just it hasn't stopped.
Thank you. Any questions, Mr. Rojas?
Sorry.
When was that rehab?
It was 2 years ago.
And you guys were still married at that time?
Yes.
And when's the last time you actually saw him take a drink?
Right. He was drunk when he came to my house and got arrested. Yeah, he's been drinking up until he got arrested.
And that was in January.
Yes.
Pass the witness, Judge.
All right. Thank you very much, ma'am.
Can I turn that?
I'm standing right here.
Okay.
Any other witnesses?
No.
All right.
Can I call my witness?
No, you have an attorney. Mr. Couch, what you're doing today is giving me more and more concern about whether or not I should even follow this agreement. You are interrupting, you are denying everything. In fact, I already had a mark in this pre-sentence report that you pretty much your version of the offense is not what the version, the official version is, and it's not accepting responsibility. Flat out not accepting responsibility. So if I'm going to go along with this agreement, it is going to be with help, whether you think you need it or not. So at this time, in cause number 26, DCCR 0328, going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm going to follow the agreement and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include entering and successfully completing the safety program. You have, it sounds like, people who love you and care about you and want you to do better. It's going to be up to you to do that. Part of your probation is going to be to have for sure, no in-person contact with Allison Couch. If there is at the time through probation that communication is helpful and positive, then I would allow that, but that's going to be through probation and through your family and or Ms. Couch reaching out to them and saying that that's okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I hope you take advantage of this, Mr. Couch.
Ma'am, can I make one more statement, please?
What's that?
She got all my property. She's got all my property, my IDs and everything. I can't even get money out of the bank or anything because she has all my property. Can I have a week or something to get my truck out of the tow yard and I'm gonna lose my truck?
No, I'm sure it sounds like there's people that will help with that.
There
Talk to Mr.
is no
Rojas.
one, Your Honor. There is no one.
Well,
I can't even make a phone
I'm not
call.
going to let you out. All right. You can go back with the bailiff.
How do I do that?
That's what she's doing.
And you find yourself in a situation where you're getting sent off to safety, and all you can think about is getting your truck. It's locked up in the impound, out of the impound. And mind you, it's been there for over 6 months now. That truck's gone. It's gone. You know it is. There's no chance it's still there. He's been locked up since January. And all he wants to do is get his truck out of impound. He got it locked up in impound for driving drunk. Here we are. But you know, he doesn't do drugs and he never drinks. But here we are. We're all gathered together for his sentencing on a Tuesday afternoon. Well, I hope he has a good time. It's safe P. I hope he gets the help he needs. I'm with the judge as far as that's concerned. And among everything else, I just 17 years, y'all. That guy got 17 years. The dude who shot the other guy in the face only got 10. Or actually, I think it was less than 10. Now, there was a jury involved with that one. So I can't blame it on the judge. No. I don't. You know what I do need to do? I need to say a hearty thank you to Sovereign Legal Encounters and Scott McIntosh. They're both heroes of the night with the super chats. Gotta make my chair squeak a little bit. Yeah. There we go. Figured that's something y'all needed to hear. My leg hurts. I don't know why. I guess I've been sitting in a weird position for the last 15 minutes. Guys, it's been a great chat. Thank you all for hanging out. It's been amazing. We started things off with Judge Middleton. Miss Good Kitty, look at you. May the force be with you also. We started things off with Judge Middleton. And man, I enjoy the small town flavor that we get from Judge Middleton. I hope we continue getting more from that area because those stories are so interesting. And I'm dying to know how things are going to go after Judge Middleton is done with his tenure. Look at that. Look at Miss Kitty. Miss Good Kitty. Thank you so much again. We moved quickly on to Judge Aquilina, who took her opportunity to give a guy a full year. 365 days mandated. She said, I have the capability to give you 365 days of mandated jail for probationary purposes. And guess what, sir? You're getting day for day. Each and every one. Those are not good time days, ladies and gentlemen. Those are day for day. After Judge Aquilina, we moved on to Judge Stevens. And man, you don't want to cross Judge Stevens like that. Make it seem like you're trying to negatively influence witnesses and stuff like that. It just doesn't go well. And I can't say any more about Judge West. Same Wolf time, same Wolf channel tomorrow. I'm your Lone Wolf Oosel. I do it every day. For now, I'm out. And remember, only you can take a bite out of crime. Bye! Thank you, Ginger.